We will now begin our 30 seconds of rebuttals. Mr. Zitch, you begin.
I don't really have much to say. I think the alternative programs, any alternative programs to jail for individuals that we think we can rehabilitate or treat is important. We obviously don't want to throw away folks that we can put back into society to become productive members of society again. On the other hand, I do think that we need to follow the law and apply the consequences of anyone's actions to what they've done.
So I've observed in the Lewisburg community, no disrespect to Judge Armbruster, but I've noticed people on the diversionary program who don't seem to really be taking it seriously. The only change that I would look at would be to make sure that the people that are involved in the diversionary program are actually taking it seriously as a consequence to their conduct that is unacceptable to the community. And if they are not taking it seriously or in compliance with that, to find another consequence for them.
Just to expand on what I have been saying initially, one area that I'd like to look at actually expanding the program, and this is something I've discussed with President Judge Hudak, is regarding first-time retail theft offenses. At the Union County Resource Center, they now have a retail theft prevention program. Anybody with a retail theft that reaches the common pleas level is routinely sentenced to it, and I'd like to explore whether we could use that at the magistrate level for first offense retail theft so that there isn't a second offense or a third offense that reaches the court common pleas.
We will now begin with the audience questions, and question 3 is this. What are your thoughts regarding determination of bail in regards to addiction, addicts, and drug dealers? And on this one, we begin with Ms. Lincoln.
So determination of bail needs to be based on the gravity of the offense and whether there's a risk to the public. So certainly with any offender that comes before the district magistrate needs to give careful consideration to conditions of bail and balancing, as I stated, the offense, the gravity offense and the risk to the public. Certainly there are laws that support that, and I would work to uphold those laws.
When you're talking about bail, as Ms. Lincoln said, you're balancing two important factors. It's the protection of the public and the need to secure the defendant's appearance at future hearings. Really, when you get down to it, it's protection of the public versus the defendant's freedom. This is a decision I've been making as a mental health review officer for over 5 years. Specifically regarding drug offenses, I think there's two things that are very important. One is considering whether mandatory treatment should be a condition of bail in certain cases. That's something that Mike Toomey, the magistrate who serves the Sunbury area, has done since taking office, I think with remarkable success. The other is what's called a nebia hold. This would apply to drug dealers. It's not used very often in this area. I've had a couple Lycoming County cases where it's come up. And basically, a nebia hold requires a separate hearing to make sure that the funds being posted by a drug dealer are actually legitimate funds. In other words, you don't want them to buy their way out of jail with dirty money.
I certainly agree that bail is in place to ensure that the person arrested will return to the court in the appropriate time frame. I think that a lot of the bail regulations are set by code, but we can look at those, I think, and interpret them in ways that are more conservative or more liberal. And I think that if, as my colleagues have noted, if we don't have a risk of flight and the crime is in the range of those in the code, I think the bill sort of sets itself. But my belief is that we really should be with drug dealers and repeat drunk drivers, more conservative in how we're approaching the bail.
We will now begin rebuttals on question 3, and we will begin with Ms. Lincoln.
So certainly, it is important when an offender comes before the district magistrate and the district magistrate is challenged with issuing bail against an offender. But it's very important to pay attention to, again, what is the risk to the public, and follow the law as it's enumerated in the code. I think that a conservative or liberal approach could be dangerous depending upon what the offense is, and I think that it would just be important to make sure that the public safety is paramount when you are issuing bail against an offender.
One factor that I'd like to address very briefly, which is more of a practical matter, is the capacity of the Union County Jail, I believe, is 34, and it's only men. So that means with community protection concerns, you have to get a little creative. Our probation department has utilized different kinds of bail, intensive supervised bail, meaning that the offender is on an ankle monitor. They have to report to a probation officer every day. Then the step down to supervised bail, where no monitor, but they're still reporting every day. Cash bail isn't the only option.
I think that we need to seriously consider what we're letting back out onto the street. I'm not a criminal defense attorney, and I've never argued against the imposition of bail. But just because the jail might be full doesn't mean we can just turn people out onto the street. We do have a community to protect, and I think it's important that we recognize that.
Thank you. We will now go to question 4, and Mr. Rao, you will begin with the answers there. Okay. Question 4 is, if elected, will you continue the program created by your predecessor, the alternative adjudicative disposition for first-time offenders? Why or why not?
I believe we already addressed that. So, in the interest of the audience,
They've already heard us.
Yeah, and they did.
At least it's similar to
Yeah, it's very.
the previous question.
Yeah.
Okay. All right, let's have new question 4. Thank you. Thank you for paying attention.
I tried.
Fine job of paying attention. Question 4 will be, how will you approach fiscal responsibility in the courts? Mr. Rao.
Well, I think that's one thing that Judge Armbruster has done very well over the years. If you've ever been inside his courtroom, you know that it's not the fanciest place in the world, and I don't mean that in a bad way. As with any elected position, you're a steward of taxpayer money. There is an issue with staff size. For a number of years, he had 3 staff members in there. Currently, he's down to 2. I think we need to examine whether we can still go with 2, whether perhaps there needs to be a floating position between this office and Jeff Mensch's office out in Lewisburg, or whether processes can be changed to make it run efficiently with 2. That's really all I have to say on it.
I think that expanding programs that involve mediation or arbitration of matters that